Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can shake your head all you want. I'm just going to leave it there. We'll see you.
Today we're stepping into a courtroom where things go sideways fast. A defendant who's been sitting in jail for 2 weeks is demanding his preliminary exam now, even without full discovery. His attorney is trying to hold things together. The prosecutor is dropping bombshells about jail calls and witness tampering, and the judge? He's heard enough. This is People versus Matthew King, and it gets real quick.
What are we doing?
Your Honor, we do not have discovery as of yesterday when I met with Mr. King. Miss Sunda, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination, and he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
Your Honor, at this point, I would be objecting to that, given that I have...
Stop right here, because this is a critical legal moment. The prosecution is objecting to scheduling the preliminary exam, and for good reason. There's a second venue with additional surveillance footage of the actual assault. There are jail calls that could lead to new charges. And there's a follow-up victim interview still pending. This case is still being built, and the defendant wants to rush into a hearing before all the cards are even on the table. Classic high-risk move.
Along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go.
That's fine.
Pardon?
He said that's fine, Your Honor.
I'm in jail 2 weeks. I ain't did nothing wrong. They always try to do
well.
And here it is, the moment that humanizes everything. Mr. King speaks up directly. I've been in jail 2 weeks. I ain't did nothing wrong. And you can feel the tension in that room. The judge's response is firm but fair. Rushing the preliminary exam could actually keep him inside longer because the prosecution won't be ready and the hearing could get adjourned anyway. Being in a hurry in the legal system can seriously backfire.
You are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay. Here's what I'm going to do. That the discovery that you have now, you can get over to.
It was sent yesterday, Your Honor.
It was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further steps along with that surveillance video from where the actual assault occurred, and then potentially, and then Ms. Gaines would also get the jail calls that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm going to do something with the date because everybody seems to be in a hurry. So I'm going to set an in-person preliminary examination. I'm going to set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Right. Thank you.
As the bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family.
Now this is where the case takes a completely different turn. The prosecutor reveals she's been listening to Mr. King's jail calls, and what she heard is alarming. He's allegedly telling family members to contact the victim's mother, and the victim here is his own minor son. This isn't just bad optics. This is potentially witness tampering. And here's the kicker. Mr. King is already on parole for a prior witness intimidation case. The judge's face says it all.
The victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering case as well.
Okay.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother and his sister He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well, I'm
cannot have only direct contact, Ms. Gaines. As you know, he can't have indirect contact.
correct. I'm not disagreeing with that. I'm just saying that based on our and terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right. What I will do is I'm going to
Watch this ruling closely. The judge revokes Mr. King's phone and texting privileges entirely, right here on the spot. And Mr. King loses it. I haven't done anything wrong. You're taking my phone. But the judge doesn't flinch. When you're already on parole for witness intimidation and jail calls suggest you're trying to influence a victim, a minor, your own son, a judge isn't going to give you the benefit of the doubt. This is what accountability in real time looks like.
I want to do one today. Like you taking my phone, Mr. Sampson, and I ain't called him. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted none of them.
bond conditions were that you cannot.
That was People versus Matthew King, a case that started with a defendant demanding speed and ended with him losing his phone privileges and facing potential new charges. The lesson here? In a courtroom, patience isn't weakness, it's strategy. Rushing a preliminary exam without full discovery, making jail calls about your victim, trying to influence a witness who happens to be your own child. Every one of those decisions made this situation worse. If you found this breakdown valuable, hit like, subscribe, and turn on notifications for more real courtroom cases breaking down exactly like this.